I'm Stephen Brown with Reddy Neumann Brown P.C. here in Houston, Texas. And, today I just wanted to talk about something I haven't gotten on video to talk about in a while, and it's just immigration delays and kind of some strategies around how to handle these delays. We know one of the big issues in Trump 1.0 was delaying benefits. Whether it was H-4 EADs or L-2s or consular decisions, green cards, whatever it might be, because delaying them is as effective as denying them sometimes. People might lose their jobs. And that was, again, the strategy of the first Trump administration. And we're seeing a second administration that's even less friendly than the first. And so wanted to put this out there. We have started seeing an uptick in processing times. I mean, if you go look at USCIS posts historic processing times for each fiscal year, and really fiscal year 2025 has predominantly been the Trump administration. It started October 1st, 2024, all the way till the date of this video. So a few months of President Biden and majority of it during President Trump. But if you look, a lot of these are already seeing increases. You go look at 485s have already gone up, about a half a month in processing. If you look at I-539s, it's down, but again, we're starting to see that downward trend. I-129s are back up on non-premium cases. It's actually up over a month. And so EADs, starting to see that trend as well. So it's starting to prepare for these delays. And so what can you do with this? We're seeing the increased scrutiny happen. And so what can you do? And so things to consider. One, file early. If you can file your EAD right at the 6-month mark, file your status request right at the 6-month mark. Obviously, I know some people are kind of having to wait for employers, but it's something filing early can help reduce it, as best you can, especially in cases where there is automatic extensions, right? Like the C9 485 EAD, that certainly helps. The other thing, we're here. We've done litigation. We are way better prepared as a immigration law firm. The law firms across the nation, but we did a lot of litigation in the first Trump administration. We did a lot during the Biden administration too. So it's not like it went away. But we're preparing, we're prepared to do this again if we need to. And so a couple things that we have litigated on that we've seen success with: H-4, H-4 EAD, L-2s. These are very ministerial actions. These shouldn't take more than, a handful of little bit of time to adjudicate. There's very little factors. And so, if you're pending beyond kind of 4 months, that's something we can bring, for litigation, because, you're going to cross kind of that 6-month threshold, likely lose work or lose status, lose the ability to drive in some states. And so these delay lawsuits, writ of mandamus, WAM, whatever you want to call it, can be very effective in the EAD context, whether it's the H-4 EAD, whether it's the C9 EAD if you have to, but that can be effective. The 485s, obviously not a huge, uptick of adjudication during the Trump administration, but we did do a number of these cases during the Biden administration. They're a little bit weird because there's some hurdles we have to get through, but the current trends are pretty good. We're seeing a lot of good traction on these cases, especially if it's pending, over a year and a half, depending on kind of your situation. And of course, your priority date needs to be current. If I sue on a delay, of a non-current visa, you're just going to get a denial. All right. But we've, brought these cases. These aren't one size fits all. Some people, I can tell you, I was extremely aggressive with one individual because he couldn't work until he got a green card because he needed a certain security type clearance. Not a security clearance, but a card that's basically like that. And so we were very aggressive. Others, 2-year mark, year and a half, maybe a year, for that. Especially 526Es, the EB5 folks, the EB1 folks, I think we could be more aggressive with as well. Advanced parole is a big one, all right? Especially with how bad consulates are right now. I try to avoid going to the consulate if you can. And so if you are eligible for advanced parole, the downside of advanced parole is it doesn't do the automatic extension like the EAD does. So something to reach out on. Again, we're starting to see slowdowns in all these categories. And so hopefully it's not going to creep up the way it did, but I don't want, in my opinion, if it were me, I don't want to lose out. I'd rather be on the offensive than the defensive. The last two that I want to talk about are kind of unique. First off, we'll start with 221G and administrative processing cases at the consulate. These are super, super unique. There's the case law on these are way, all over the place. Some judges will be like, well, statute 221G says refusal, so I can't take a look at it. There's some judges that say, no, wait a minute, you're still working on it. There's got to be reasonableness to this. So just, something that if it crosses, I would say, 4-6 months we could possibly look at. But again, I want to have that conversation. My kind of pet project that I've done in the last few years has been Freedom of Information Act, or FOIA, FOIA, whatever you want to call it. If you've got a FOIA pending and it's crossed that business, 20, 30 business day deadline, we can be aggressive because the statute's pretty clear on that. And this can be effective when you're trying to get, policies or information relating to data that they don't present. So just to kind of recap on what to do, right? Let's avoid delay issues. File early. If you can file early, great, do it. File as soon as possible. And think about litigation proactively. Again, litigation is a tremendous tool. I think it can be very useful. And there's a lot of positive factors, I think, of right now with how the judiciary is looking at some of these things. I'm not saying you need to be so aggressive that you file like a week after your case has been filed, but take a look. And the big thing is you don't have to wait for it to be outside of normal processing time. The question becomes, is it reasonable? There's a good case out of, I think it was the Sixth Circuit, where it was a U visa delay case, and the court said, well, we're not going to really fixate on the processing times. We're not going to compare snails against snails in a snail's race. Basically meaning like all of these could be unreasonable. Okay. And then just, again, we've got the experience. There's a lot of, options here for litigation, and, feel free to reach out. Happy to talk. I like to set up folks, make sure this can be effective for you. And we're setting good expectations. But again, delays are going to pop up again. And it's, I think we, and I mean the collective we, the immigration community and, our firm, lawyers across the U.S. are better prepared because we've dealt with this once, and we're ready to fight again. So, again, reach out if you need anything, and thanks for tuning in.